So those potential outcomes are we have the ability to fully demonstrate compliance with CQS, and we also have non-compliances. So two different types of non-compliance, major and minor. Quite simply, one a non-compliance is where a practice is unable to demonstrate that they can evidence compliance with a particular requirement of the standard. So the only difference between the major and the minor is actually the amount of time that you get to fix the problem. So there is an opportunity to fix, there is an opportunity to undertake corrective actions. And as part of that feedback meeting, we will let you know what our findings are. And then we'll have a conversation about whether we consider that should be a minor non-compliance or a major non-compliance. And we'll always take into account the fact that you have a day job, you've got a caseload to run quite often, and what you don't want to do is to have any non-compliances assigned to you as a minor, and then set yourself up that actually you might not be able to fix those within 21 days, and that's when you'd find that you would potentially fall into the next part of the process, which could be for some firms suspension or eventual revocation of their accreditation. So we're very careful in making sure that we do collaborate with you to identify whether it's a minor or a major. So a quick example, minor non-compliance, quite often I see in practice the initial correspondence to the other side's conveyancer, protocol requirement whereby you need to identify to that firm the name of the parties and also the property price. Quite often we'll see the property price missing. So that's a quick fix. That's something that can be fixed within 10, 15 minutes, either through your own resources internally. If you've got an IT manager, whoever your developer is, they can just do some quick recoding to pull in the information from the case management system. Or if you've got a template, if you don't use a case management system, just some some rejigging of the template, run off a new template, show us, and that's it. That's fixed. So that would be a minor non-compliance. An example of a major non-compliance would be, say, for example, we go to a practice and they said that we don't have an anti-money laundering policy, for example. That's not a quick fix. Okay, it's not just a case of just going and buying a policy. It is about defining what your policy is in your practice, setting out your stance, which is the policy, making sure it aligns with legislation, and then developing all of your corresponding procedures that you will do in practice, and then deploying those, incorporating into your daily tasks, case management system, the way you work, training people, embedding it, following it for a certain amount of time. So that's the kind of thing that we would identify as a major non-compliance, because you cannot possibly do that in 21 days. So you see the two different angles there. So the only difference, like I say, is the amount of time you get to correct the issue. Once you've done the corrective action and you provide evidence to the Law Society of that corrective action as defined in the report, so you'll know exactly what it is that you need to do, and that would then satisfy the Law Society. So what some firms need to be careful of is, like I say, not dealing with the corrective actions in the right timeframes, or indeed, not engaging with the Law Society. And there's also the possibility that practices may not deal with the corrective actions to the satisfaction of the Law Society as well.